Once again, I apologize. We are certainly 25 minutes later than we had anticipated, so this will be a very brief introduction, although I do feel some obligations. Good evening, my name is David Mitchell. It's my pleasure to welcome you to the University of Missouri School of Law for this evening's presentation, Liberty and Justice for Some, the two-tier justice system. And before I introduce our featured speaker, it's my duty, of course, to thank those who made this event a possibility. Chancellor's Diversity Initiative, the Studies, Joan Hermson, the Women's Studies, Gender Studies Department, Social Department, History, Forefront, the MU Muslim Student Association, Dr. Wilbur King, the Black Studies, the ACLU of Eastern Missouri, the Center Project, Howard County Progressive, Good Missouri Fellowship. These are all on the program. I'm not going to read them again. What I will say, however, is this, is that this project is a reflection, if you will, of the collaboration between academics and activists. It is the bridge between the college and the community. This is one of those rare events, in effect, where individuals from the world of academia, the ivory tower, and those who are on the front lines, the grassroots individuals, have come together for this presentation. I thank them for all of their hard work. I thank the ad hoc committee, individuals from, not only from Columbia, not only from this university, but nationally and regionally from other organizations. Okay? I had a whole lot of wonderful words. But we will defer those, because you didn't come here to hear me speak, although I could take that prerogative. You came here to hear Greenwald speak. All right. When the idea of this event was proposed, initially it was a grandiose vision. It was going to be a day and a half long conference, but we couldn't decide on a date. And certainly no one that didn't coincide, we didn't want to have this coincide with the other major events that occupy Columbia on Saturday, the Farmers Market. Common sense prevailed. We settled on one evening, and at that point, we determined that we had to choose a speaker, someone who would have appeal. Clearly, he has appeal. Clearly, this topic has appeal because of the number of folks in this room. This is a fantastic turnout. I'm embarrassed to say, however, when Glenn Greenwald was suggested as a speaker, I didn't know who he was. And I'm surprised I didn't, since my work focuses on disparate and disproportionate impact, on social justice issues, on racial minorities and their relationship with the law. So, it was clearly a hole in my own education. And yet, so, I was unfamiliar with this. But I was certainly in the minority. When I approached one of my colleagues, our First Amendment expert, she said she was thrilled about the prospect of Glenn Greenwald coming to speak. Another colleague, our sentencing expert, said, noting that he had read Glenn's blog and was actually anticipating his arrival. Numerous conversations and some much needed research on my part, I too am extremely excited about the prospect of hearing Glenn Greenwald this evening. In his words, Glenn engages in critical analysis that is neither captured by ideology nor by sentiment. In a time when one is labeled unpatriotic for engaging in critical analysis of our government, Glenn Greenwald displays a rare form of courage. If you take away nothing else from this evening, it is important to engage in critical analysis. The Founding Fathers were critical of their governments, and hence the birth of a new nation. The Civil Rights demonstrators were critical of their government, and hence the end of Jim Crow. But if you read Michelle Alexander, of course, there's a new Jim Crow. Women were critical, and hence they had the right to be full citizens and exercise the right over their control over their own bodies. Be careful. And Muslims and Latinos, of course, are critical in the hopes that encroachment on their civil liberties will one day come to an end. Glenn Greenwald is a columnist on civil liberties and national security issues for The Guardian of London. From 2007 to 2012, he was a contributing writer at Salon.com. He's the author of 4 books, 3 of which have been New York Times bestsellers. How Would a Patriot Act, 2006. A Critique of the Bush II administration's use of executive power. A Tragic Legacy, 2007, which examines the Bush legacy. And with Liberty and Justice for Some, how the law is used to destroy equality and protect the powerful. Analyzing the entrenchment of the two-tier U.S. justice system. The other book, Great American Hypocrites, examines the myth-making and exploitation of cultural, gender, and psychological themes by the Republican Party. In March 2009, Glenn Greenwald was selected, along with Amy Goodman of Democracy Now!, as the recipient of the first annual Izzy Award by the Park Center for Independent Media, an award named after the famed journalist I.F. Izzy Stone and devoted to rewarding excellence in independent journalism. Glenn Greenwald regularly appears on various radio and television programs as a guest political pundit. The Columbia-based community radio station KOPN-FM at 89.5 on the FM dial, for one, has featured Glenn's insightful commentaries many times over the past several years. And Chautauqua with host Deb Leach, 6 o'clock, and on Democracy Now! After practicing law briefly for a private firm, he co-founded his own law firm in 1996, where he litigated cases concerning issues of U.S. constitutional law and civil rights. Glenn Greenwald earned a Bachelor of Arts degree from the George Washington University and his JD from New York University Law School. He was born in New York, So we'll call him a native New Yorker, but for his Manhattan Heights, he was actually born in Queens. So not really sure that actually counts. In any event, it's a pleasure to introduce Glenn Greenwald.
Thanks very much for coming out this evening. I really appreciate it. I'm sorry for the little drama before the event. I hope it was a little exciting at least. And I apologize, and please extend my apologies to the dearly departed who are in the back there. But hopefully they'll be able to watch it on videos. And thank you so much as well to the student and community groups who helped to sponsor this event. And a special thanks to the National Coalition to Protect Civil Freedoms and to the law school, which played a really integral role in enabling my coming here. So the title that was given to the event is With Liberty and Justice for Some. And that is a title that is taken from the book that I wrote and that was released last year. And that is a book that I wrote in order to make the argument that the rule of law in the United States is being not just violated, but explicitly repudiated. And this distinction between violating a principle and expressly repudiating a principle is one that I think is profoundly important. And yet before I talk about that, I want to talk first about the question of what is it that we even mean when we talk about the rule of law. That's always the first question that I begin with whenever I talk about any of these issues relating to that topic. And the reason I do that is because there are a whole variety of phrases that are extremely commonly invoked in our political discourse that really don't have a very clear meaning. People throw lots of terms around all the time without paying much attention to what it actually denotes. And I think the rule of law is one of the leading examples of that dynamic. It's sort of a cliche at this point. It's something that's a concept to which everybody pays lip service. So you'll hear politicians or people in the media or even citizens all the time standing up and saying, I believe in the rule of law. It's not really a debated issue. You'll never hear somebody stand up and say, I just want you to know that my position on the rule of law is that I am opposed to it. It's just sort of a slogan at this point. And yet it's used quite frequently, and so I think it's profitable, especially if we're going to spend a little bit of time talking about it tonight, to first ask what it is that we mean by it. And one of the things that first comes to mind from a lot of people when they hear this term, the rule of law, is the famous proclamation by John Adams in the Massachusetts Constitution when he said, we are creating a nation of laws, not of men. And although this is sort of taken on the status of cliche as well, it's actually an extraordinarily revealing and important phrase to think about. Because what Adams is really saying is that there are only two options when you're forming and then sustaining a society. There really are only two choices. There aren't three or four or more. You have to pick between one or the other. And the two choices are you can be a nation of laws or you can be a nation of men, which is, of course, founders speak for human beings. And what a nation of men means is that whoever wields the most power will be able to exert their will without constraint. That's what a nation ruled by men means. That's the nation, the kind of nation that the founders fought an extraordinarily risky war to free themselves from, in which they didn't want to replicate. And so they sought alternatives to living as a nation of men, a nation subject to the will of those who are most powerful, who can exert their will without restraint. And the only option that they could find, the one that they ultimately embraced, was this concept of a nation that lives under the rule of law. So it wasn't just sort of an ancillary concept, it wasn't a slogan to the founders, it was completely instrumental to the republic that they were constructing, to preserving anything that was worthwhile or just about it. And so I do think it's particularly important to look at what they understood by that term and then ask what we understand by that term as well. And even though it's such an important term, it's really not ultimately that complicated of a term. Because really, as I said, is all it really is intended to do is to serve as an alternative to living under a nation ruled by men. And the only alternative would be something that is superior even to the most powerful person in the society. Something to which all human beings, regardless of power or position, are subordinate. And that's what they ultimately ended up conceiving as the rule of law as being. It's a common set of rules to which everyone in the society, regardless of power, prestige, or position, are commonly bound. And the reason why this is such a critical concept to them and why it's such a critical concept to us is because if you look at what the founders talked about, we talk about all the time about the founders believe this, the founders believe that. It's very difficult to actually think about things in that way because they were incredibly disparate people who were spanning the ideological spectrum and had all kinds of vociferous debates and disagreements amongst themselves on core issues. But one of the things on which they all agreed, probably the only thing that I would say was a really clear consensus, was that the rule of law had to be continuously affirmed as a centerpiece of the republic if it were to make any sense what they were doing. And the reason for that is that if you look at what the founders viewed in terms of inequality, all of them, literally all of them, agreed that vast inequality would be inevitable. There would be inequality in wealth so that some people would be very rich and most people would be very poor. There would be inequality in power so that a few people would be very powerful and the vast majority of people by definition would be ordinary or powerless. And most of them thought not only was that inevitable, but that that was desirable. They wanted there to be outcome inequalities, differences in wealth and position and power and prestige. And some of them, like Thomas Paine, who didn't want that to take place, who didn't see it as desirable, nonetheless agreed that it was inevitable, that there was really nothing you could do to prevent that type of inequality. And so what they all tried to do is to figure out a way, given the inevitability of this inequality, to at least make that inequality legitimate, to at least make it just. And that's where the rule of law comes into play, the idea that the only way we can accept differences in outcomes, outcome inequality, especially vast differences in outcome inequality, is if we're all bound by the same set of rules, which then legitimize those inequalities. So the way I always typically analogize this is if there's a running race and everybody starts at the same starting point and has to abide by the same rules, stay in their lane, or they're not able to elbow other runners out of the way, they don't have any relationship to the judges, it's all at arm's length, we accept that the person who crosses the finish line first is legitimately decreed to be the fastest and reaps rewards, and the person who is the second fastest, and so on. We accept those outcomes as legitimate because everybody was bound by a common set of rules. But if one person were able to start far in front of the other racers, if they were able to kick and trip and elbow other people out of the way, if their cousin or their brother or their parent were the judge making decisions about the race, we would not accept those outcomes as legitimate. We would consider them inherently illegitimate. That's the role that the rule of law was intended to play in America, was to ensure that outcome inequalities, which they saw as inevitable, would at least be legitimized and just in some minimal way, by binding everybody to the same set of rules, regardless of power, position, or prestige. Now, as I started off by saying, there's a huge difference between violating a principle and expressly repudiating a principle. So it is, of course, the case, I doubt anyone in this room needs to have it pointed out, that since the founding, since the inception of the Republic, there have been not minimal, but violent and fundamental breaches of this principle. In fact, the nation was born as one big throbbing violation of the principle of the rule of law. Obviously, we were not all bound by the same set of rules. We were subject to completely different rules based on our position, power, and prestige, by race, by gender, by status, by property ownership, and a whole variety of other attributes. But even when that principle was violated, its centrality was still affirmed. It was still the animating principle of the Republic, and it's what enabled many of those violations ultimately to be rectified. So if you look at the emancipation of slavery, or the elimination of Jim Crow, or the enfranchisement of women, or greater equality based on socioeconomic status, what you find on behalf of the people who are advocating those changes is an appeal to this principle, to the idea that even though we're going to have inequality in lots of other places, the law, the realm of legality, is the one place where inequality should be unrecognizable, where superiority in power and position and wealth should not be a commodity that makes any difference. It was because we affirmed this principle that we were able to rectify so many of those original deficiencies. So much of American social progress is driven by our continued belief in the principle, even when we violate it in all kinds of radical ways. And so it's extremely important, even when a principle is being violated, that it continue to be affirmed. And the reason I ended up writing this book and why I focus so much on what I call America's two-tier justice system is because I don't really think it's the case any longer that we simply violate the principle of the rule of law. I believe that we have actually repudiated it, that we no longer believe in it, that it's very common to hear explicit arguments about why it no longer is a valid principle, especially among the class of political and economic elites, the people who generally tend to exert the greatest influence on our political culture and our legal framework. And I want to just share a little personal anecdote about when I first started realizing that that was true, although I didn't really fully articulate it as I just did. I sort of started getting the sense that there was something very wrong in terms of how we think about the rule of law. I began writing about politics in 2005. And shortly after, I just spontaneously created my own blog one day without any real purpose or plan or even understanding about why I was doing it. Maybe 6 weeks later, the New York Times revealed on December 15, 2005, that the Bush administration was spying on the telephone conversation and email communications of American citizens without the warrants required by the FISA law, the law that had been in place for 30 years, that said that it's a felony to intercept communications of American citizens without first going to the FISA court and obtaining warrants. And when this scandal was when it first emerged, and I confess this with some degree of embarrassment because I was laboring under a pretty extreme amount of naivete at the time, I see retrospectively, I actually thought that this was going to be a pretty simple scandal. Like, I actually thought, at the very least, that everybody was going to agree that when there's a law in place that says that it is a criminal offense, a felony, to eavesdrop on the communications of American citizens without first getting warrants, that everybody would agree that at least it was a bad thing that the president went and did exactly that which the law says that you cannot do, which is spy on the communications of American citizens. And I thought the debate was simply going to be about what sanction would be appropriate in light of these blatant, demonstrable, and indisputable violations of the law. Would prosecution be warranted? Would there be impeachment proceedings? Would there be some formal censure? I thought that would be the debate. And I remember around this time, this is really the first time that I started doing any sort of media appearances or participating in political discussions and debates on television and on radio. And the reason for that was my work wasn't very well known. I had just started writing, but there was very few people who were actually making the argument that what had been revealed was actually a crime and should be treated as such. And so when television producers wanted to have a debate, it was really hard to find somebody who was making that argument. They would do Google searches, and somehow they would find me, and they would call me, and they invited me onto these shows. And I remember I'd gone to these shows, and I had the expectation that it was going to center, the discussion would center on the fact that the president had got caught violating the criminal law. I mean, it's really a criminal law. It says, if you do this, you will go to prison for 5 years, or a $10,000 fine for each offense. It's part of the criminal law. It's a violation of the law like kidnapping or bank robbery or embezzlement or murder or any other crime that gets committed. So I thought that would be the premise of the discussion. You know, I would go on these TV shows and I would get asked about everything except for that, the fact that it was a violation of the law. So I would get asked things like the topic would be, well, should the Democrats really challenge President Bush on this issue? Won't that be very bad for them in the midterm elections? Or how can anyone object to what President Bush did when it was done to keep us all safe and protect us from the terrorists? And I remember the experience, the sensation that I had. I was legitimately baffled. I was confounded. I was actually kind of confused. And all I could say whenever I was participating in these debates, I just kept saying over and over, I know, but it's against the law. It's illegal. It's criminal, because I actually thought that mattered. And I know, as I said, I say that with a good degree of embarrassment about the extreme naivete under which I was laboring, that it actually mattered if the president broke the law. It didn't. And the reason it didn't is because there was this explicit sense that political leaders who exercise political power, especially high-ranking political leaders, who break the law with the political power that they exercise, really don't belong in a courtroom or the subject of an indictment or being criminally prosecuted. That those kind of procedures are for drug dealers on the street corner or for poor people who commit crimes in order to try and find some method of sustenance. But it's not for our high-ranking political leaders. The idea, the very idea that I was advocating, that there should be criminal sanctions, just like there is when ordinary Americans break the law, based on this appeal to the rule of law, that we're all subject on equal terms to the same set of rules, was really treated as though it were radical or crazy or from a different planet. And that's when I really realized that this idea that I had that I thought was a basic consensus, the rule of law, that we're all bound on equal terms to the same set of rules and guidelines, it was really not something that people believed in. It wasn't just that it was being violated, it was something that had been explicitly renounced. And then I remember at the beginning of the Obama administration, when President Obama was first inaugurated, there was a lot of debate about whether or not criminal investigations would be commenced by the Justice Department to investigate crimes that had been committed by the Bush administration during the War on Terror. Things like the construction of the worldwide torture regime, spying on Americans without warrants, lying to Congress about many of these things that lots of legal scholars had said were clearly criminal. And what immediately emerged in the media world in which I was participating in this debate was that it was a virtual consensus again, a Washington consensus certainly, and a political and media consensus as well, that criminal investigations were not appropriate for any of these crimes that had been committed. And the argument that was made almost invariably was not that it's not criminal to authorize torture, or that it's not criminal to spy on Americans without warrant, or that it's not criminal to lie to Congress about the things that had been done. Everyone basically acknowledged that those acts were indeed illegal. Again, the argument that was made was that criminal investigations were inappropriate because people who are sufficiently powerful, who are high enough ranking in political importance, shouldn't be subject to criminal prosecution because it's too disruptive to our society, that it's more important to embrace political harmony and to move on than it is to hold people accountable under the law. Again, it's an explicit renunciation of the rule of law. It's really an argument that those who are in sufficiently high places should be immunized from the rule of law, not just for their good, but for our common good. It's in all of our good to ensure that those who are most powerful aren't subject on equal terms to the rule of law. And that's when it really became crystallized for me just how complete and pure this renunciation of this principle was. Now, one of the important things to note about this is that if this leniency, this impunity, were applied across the board, then it wouldn't present a rule of law problem. So if everybody had the same ability to appeal to these principles that are invoked when it comes time to immunize the most powerful people, if everybody had the ability to seek leniency and obtain it, or seek immunity and obtain it when they got caught breaking the law, no matter what station they are in life, how powerful or well-connected they are, then it wouldn't present a rule of law problem. You could have debates about whether that's the correct criminal justice policy. There are countries in Scandinavia, there are some in Latin America that have adopted extreme leniency as their criminal justice policy. And you could have debates about whether or not that was an advisable thing to do, but it wouldn't implicate the rule of law question because at least we'd all be subject to that same degree of leniency. But that is absolutely not the case. In fact, the exact opposite is true. When it comes to ordinary citizens, people who are powerful or wealthy or well-connected, a completely different universe prevails. So that rather than being able to seek impunity or be immunized for the consequences of their crime, they have one of the world's harshest and most unforgiving criminal justice systems come crashing down upon them. And if you have any doubts at all about this disparity that I'm describing, there's a good way to test it. I wouldn't actually recommend doing this, but if you're really interested in seeing if what I'm saying is true, you can do a test. You can go commit a crime, you can go rob a bank, or you can go and drive at some outrageous speed, and when you get stopped by the police, and the police come to your house and they say, you know, we're here to arrest you because we have evidence that you went and robbed this bank, you can say, okay, look, officer, you know, you caught me. I did that, you know, and I probably shouldn't have, but, you know, isn't it more important that we look to the future and not the past? Isn't it more important that that we think about how to get along harmoniously and prevent these crimes in the future, rather than figuring out who should be punished for things that happened in the past. And when you find yourself quickly handcuffed and imprisoned because you don't have license to invoke those excuses, those aren't available to you, you'll see really vividly the two-tier justice system that I'm describing. That was the argument made by first the Obama administration, then President Obama himself, as to why Bush officials should be immunized for their crimes. The Orwellian phrase was constantly invoked: we should look forward and not backward. And it was an extraordinarily bizarre way of thinking, because all crimes by definition have taken place in the past. There's no such thing as a future crime by definition. And so if you were really to adopt that mindset, not just for high-ranking government officials, but for everybody, we would open the doors to all our prisons and stop prosecuting everybody. But that mindset was invoked and is invoked only to protect high-ranking people. And so part of what I wanted to do in this book was to take a few steps back and figure out how this began and when it happened and what the implications are. And one of the incidents that I think really pioneered this way of thinking, that if you're sufficiently powerful, you are actually now immunized from the rule of law, was the pardon by Gerald Ford of Richard Nixon. And the reason why I think that's such an important historical event in this development is because if you go and look what happened there, the same type of circumstances prevailed. That is, nobody disputed that very serious crimes were committed by Richard Nixon. Everyone agreed, ultimately, that crimes that he participated in were very serious ones and would be prosecuted had it been anyone else. In fact, lots of his aides ended up going to prison. And yet, when it came time to actually prosecute him, Gerald Ford, who many historians say was selected based on an agreement to pardon Richard Nixon, went on television and had to justify to a very angry American public why it is that at a time when American prisons were overflowing, the most powerful official in the country who got caught red-handed breaking serious laws was never going to see the inside of a courtroom, let alone a prison, because Ford was pardoning him. And if you look at the speech, the televised speech that Ford gave justifying this pardon, you can watch it, and he's very uncomfortable, and he's very nervous, and he's very fidgety, because he knows that what he's doing and saying is corruptive. And what he did was he went on television, he said, and he paid lip service to the rule of law, the way that I started off saying everyone does. He said, of course, it's extremely important in America that everybody be subjected to the rule of law, regardless of how powerful. We all agree on that. But he then said he added a but, and the but was essentially intended to gut the very principle that he had just pretended to embrace. And the but was that because of his position, President Nixon has already suffered enough, that leaving office and resigning meant that he was already being punished, and that it was more important for all of us as Americans to be able to band together and put this behind us than it would be to hold him accountable and suffer the disruption and division from having done that. And this was really the template, the rationale that was created, I think for the first time, that constituted an explicit endorsement of ridding ourselves of the rule of law. Americans overwhelmingly were opposed to the pardon, but political and media elites in Washington were overwhelmingly in favor of it, and that rationale became the rationale that now gets hauled out every single time immunity is going to be doled out to our political and now to our economic elites. And so if you look at the last decade, what you find is the most egregious crimes being committed by the nation's most powerful individuals. Not only the creation of a worldwide torture regime, not only illegal spying, not only lying to Congress, but also the systemic fraud that Wall Street tycoons perpetuated in order to precipitate the 2008 financial crisis. None of these crimes, not a single one, has been criminally investigated, let alone resulted in any indictment or prosecution. None of those political and economically powerful actors have been held accountable in any way for the extraordinarily egregious crimes that they have created. What was amazing about the Nixon pardon, and I think particularly meaningful about it, was that Richard Nixon was actually a politician who rode into the White House based on a law and order platform. He spent decades arguing that American justice was too lenient, that we have to eliminate flexibility in sentencing guidelines for judges, that we have to lessen the possibility of parole for criminals, that we have to expand the length of prison sentences. He wanted to put more people in prison for longer periods of time for an ever-expanding range of crimes, and yet this law and order politician, the moment that he got caught breaking the law, was able to be completely immunized. And this is really the personification of the two-tiered system of justice that I described. If you look at the United States, and it's hard to comprehensively describe just how sprawling of a prison state it is, but there's a couple of statistics that you could look at to really underscore how the very same politicians who have vested immunity in themselves when they got caught breaking the law have created one of the harshest penal states on the planet. I think the most amazing and compelling statistic in this regard is that Americans are 5% of the world's population. So if you gathered everybody on the planet together, 5% of them would be American citizens living on American soil. And yet, of the prison population on the planet, 25% are on American soil. 1 out of every 4 prisoners on the planet is imprisoned in an American jail. We imprison more of our citizens by far than any other country on the planet, just in absolute numbers, by far more than even nations with far greater populations than we have, such as China and India. It's even a greater margin by which we imprison our citizens at the highest proportional rate of any country on the planet. We imprison more of our citizens for longer periods of time for more trivial offenses under harsher conditions than any country in the West by far. So at the very same time that we've created this immunity, this full-scale immunity for political and economic elites, we've created this harsh and unforgiving penal system for everybody else, the very antithesis of what the rule of law was intended to guarantee. And as I said, it's not just that we've abandoned that principle, but you now frequently hear arguments, intended or not, as to why the rule of law should no longer even be applied. I just want to underscore one part of this two-tier justice system that is particularly pernicious, and that is the racial aspect to it. It's pretty well documented, and we heard mention earlier of Michelle Alexander's book on the new Jim Crow, and I'm sure we'll hear discussion of it as well, the panel discussion afterwards, that racial minorities, particularly Latinos and African Americans, are wildly disproportionately punished by this extraordinarily harsh penal state. If you look, for example, at simply statistics showing drug usage, what you find is that white, Latino, and African American youth, adolescents, and young adults use illegal drugs at roughly the same rates, like roughly the same percentages. And if you look at drug arrests and drug convictions, overwhelmingly those are composed of African American and Latino youth who have wildly disproportionate representation in prison. So it isn't just that there's a distinction between ordinary Americans and powerful Americans in the justice system. There's a very racially disparate, and you could argue overtly racist, application of it as well. And we'll talk about that, I'm sure, afterwards. But there's one aspect that has become particularly disturbing over the last 10 years, and that's the treatment of American Muslims in the American justice system. And the reason why that's particularly disturbing is because what you find with Latinos and African Americans and other racial minorities, and certainly the poor, is a very inadequate form of due process. So they are processed through the justice system with barely lawyers. There's places in the United States where people who are charged with felony offenses, where they face prison for more than a decade or several decades, have an average time of 12 minutes with their court-appointed lawyer in total to talk about their case. So there's extremely inadequate due process. But for this other category of people, American Muslims, there's no due process, often at all. They're basically non-persons in our justice system. So in the wake of 9/11, we've seen American Muslims and foreign national Muslims imprisoned indefinitely without a shred of due process. Some of them are now dying off at Guantanamo, basically consigned to life in prison without due process of any kind. You see basic civil liberties like First Amendment rights being abridged overtly as American Muslims are prosecuted for things like putting YouTube clips up that are critical of American policy. And you even now see the Obama administration seizing the power to target Muslims, including American citizens, for assassination, for execution, without bothering to charge them with any crime, prove their guilt, or go to a court and demonstrate the accuracy of the accusations made against them, with almost no controversy, no backlash, no opposition of any kind. So it isn't just that we have really a two-tier justice system, we have a multi-tier justice system in which American Muslims, and increasingly other forms of other people as well who are engaged in forms of domestic dissent and meaningful protest, are being subjected to this sort of persona non grata. And I just want to end by talking about what I think are the implications of this repudiation of the rule of law that we've permitted to take root. Because some of them I think are a little bit obvious, and some of them are much less so and take some thinking about, but I think are extremely consequential. So the real question I'm asking is, what is it that happens to a society that decides that it no longer will live under the rule of law, that it will no longer be a society in which everybody is bound to the same set of rules regardless of power, position, and prestige? And the obvious answer is that you lose the value that I started by talking about, which is that you legitimize all of the other outcome inequalities. So you lose the anchor of legitimacy to the fact that some people are extremely rich and most people are very poor, some people are very powerful, most are very ordinary, because we're no longer abiding by the same rules any longer. Most of us have severe constraints, and then some of us have none. And you see greatly increased dissatisfaction over what used to be the accepted state of affairs in America, differences in wealth, differences in power, differences in prestige, rooted in the fact that there's a perception that it's no longer legitimate because the same set of rules no longer bind everybody equally. But I think there are a lot of less obvious implications to this as well that I just want to spend the bulk of the rest of my time talking about. And I think the important thing to conceive of, to really focus on, is that what law was intended to do first and foremost was provide some mechanism for constraining the people in the society who wield the most power. So if you no longer subject the people in the society who wield the most power, whether economic power or political power, to this constraint we call the law, if you immunize them from its compulsory mandates and from the force of it and from punishments when it's violated, then you're essentially liberating them from any constraints at all. It means that if people can act without the constraint of law, they're free to act in their own will regardless of any rules that as a society we set up. If the government is free to transgress the limits of law, it means that they can do whatever it wants to us, and there's really no recourse. And what this really does, first and foremost, is it creates a climate of fear among the citizenry. It changes the relationship between the citizenry and the government in very fundamental and radical ways. And it's a hard concept to convey, especially in limited time. So I just want to share one more anecdote about that really kind of highlighted that for me, and that I think illustrates the point. I have spent a lot of time over the last few years writing about the group Wikileaks, the whistleblowing site that has devoted itself to trying to penetrate the regime of secrecy behind which the US government operates and find some way to provide transparency. And I've been a defender of Wikileaks and have written a lot in defense of them and the reasons why I think they're an important organization. And the first time that I ever wrote about Wikileaks was back in January of 2010, more than 2 years ago now. And this was a time before they had really done any of their news-making leaks, like the Apache helicopter video that showed US soldiers in Baghdad shooting unarmed civilians and journalists, or the Iraq and Afghanistan war documents or the diplomatic cables. Very few people, including me, had really known very little about WikiLeaks back at this time. And the way that I came to learn about WikiLeaks was that the US government, the Pentagon, the United States Army, had prepared a top secret report in 2008 that talked about WikiLeaks. And it declared WikiLeaks to be what it called an enemy of the state. And it said that WikiLeaks was one of the few groups that was posing a genuine threat to the national security of the United States. And this report talked about ways that the government could destroy WikiLeaks. And as it turns out, sort of ironically, that report got leaked to WikiLeaks, which then published it. And the New York Times wrote an article about it, and it was a very small article because nobody knew who WikiLeaks was or why the Pentagon was plotting to destroy them. And I had read that article, and I sort of concluded that any group that the US Army was plotting to destroy was one that deserved a lot more attention and probably a lot more support. And so I went and researched them, and I had found that they had engineered a lot of really important leaks around the world exposing corporate waste dumping in East Africa and all kinds of corruption in Germany and deceit on the part of politicians in Australia. And I wrote an article hailing the promise of this group. And I interviewed its founder, Julian Assange, and I posted an audio of that interview. And at the end of this article that I had written about WikiLeaks, I included several links to where people could donate to them online, because they were sitting on a lot of important classified information that I knew about that they weren't able to process because they had staff shortages. So I wanted to encourage people to donate money to this organization. And I included some links to how the people could send money by PayPal and BankWire and other means. And in response to this article that I wrote, I had dozens and dozens of people, literally, in all kinds of venues, in the comment section of that article, by email, at events like this, where I would go and speak, come up to me and say something along the lines, and these are not people prone to paranoia, these are rational, sober people, coming up to me and saying something along the lines of, well, look, I completely understand and agree with your arguments about why WikiLeaks is an important organization that deserves support. I think extreme secrecy is a huge problem, and I want to do what I can to help it. But I have this fear that if I donate money to WikiLeaks electronically, if I wire them money or send money to them by PayPal, that I'm eventually going to end up on some government list somewhere. Or if WikiLeaks ends up being decreed to be a terrorist organization, that I could even be facing criminal liability for materially supporting a terrorist organization. And so I'm actually afraid to donate money to this organization, even though I support their aims. And the reason this was so striking to me and really shaped what I think in important ways is because WikiLeaks is an organization that had never been, in fact still has never been, even charged with any crime, let alone convicted of any crime, nor could it ever be charged with a crime, because what it does, receiving classified information from government sources and then publishing it, is a pure free press activity. It's exactly what the New York Times and CNN and every other media outlet in the world does. It could never be prosecuted consistent with the First Amendment. And here you had large numbers of American citizens who were afraid of exercising their First Amendment rights, which is what donating money to a political group whose cause you support is, afraid of exercising their right because they know that their government no longer is constrained by law, so that even though it would be illegitimate to punish them or WikiLeaks, under the law, under our Constitution, for donating money to that group, they were still petrified, rationally so, that they would be subjected to punishment if they did so. In other words, you had large numbers of American citizens voluntarily relinquishing their own rights out of fear of what the government could do now that it was no longer constrained by the rule of law. You can offer all the rights you want on a piece of paper or a piece of parchment, but if you intimidate the population out of exercising them, those rights become completely meaningless. I had the same experience when I wrote for the first time about the government's treatment of the 23-year-old Army private who's accused of being the primary leaker to WikiLeaks, Bradley Manning. And in December of 2010, I wrote an article about how he had been held in extremely inhumane, oppressive, and torturous conditions and prolonged solitary confinement, all without being charged with, convicted of any crime. And ultimately, a UN investigation concluded that, in fact, he was being held in oppressive conditions. And at the time, I remember when I wrote this article, the reaction that a lot of people had, the question that I got asked a lot, and I even asked myself was, why would the US government want to take somebody like Bradley Manning, charged with these crimes, and put him in these extremely oppressive conditions? It seems counterproductive because it turns him into a martyr. It jeopardizes their ability to prosecute him because statements he makes can be alleged to have been coerced. One prominent Obama official, the State Department spokesman P.J. Crowley, actually publicly denounced the treatment of Bradley Manning and then resigned in protest. And so I couldn't really figure out why the government would want to do this. It just seemed so against their interest. And it ultimately occurred to me that the reason they wanted to put Bradley Manning in prolonged solitary confinement under extremely oppressive conditions was the same reason that the government wants to threaten a prosecution of Wikileaks, even though it knows constitutionally it's constrained from doing so. And it's the same reason that the US government spent almost a decade kidnapping people from around the world and shipping them to a Caribbean island and dressing them in an orange suit and putting them into cages without due process and torturing them. This is all a way for the United States government to send the unmistakable continuous signal to anyone who might challenge them that we are not constrained by law or any other limits in the things that we can do to you if you oppose us. It's a way of bolstering the climate of fear to keep people intimidated and pacified from challenging them or defying them in any meaningful way. It's what happens when people who exercise power are emancipated from the constraints of law or the constraints of any kind. They are able to put people in fear of their power. And that's the climate of fear that has been created by the renunciation of the rule of law. It's the way that the rule of law really has been, the reason it has been abandoned, it's the way that the relationship between the citizenry and the government has changed so radically. You see this in so many instances. When I travel around the country and give talks like this at colleges, I typically meet with people in American Muslim communities. You can sense the palpable fear that they have, that if they speak to a new person at their mosque, that it's probably an FBI informant. If they donate money to a Muslim charity, they could be convicted of materially supporting terrorism. They can end up on no-fly lists without any cause or explanation or recourse to getting off. There's a palpable fear in numerous communities that think about opposing the United States government, because that's the message the United States government sends. If you want to expose our secrets, if you want to oppose our policies, look at what we did to Bradley Manning, look at what we did to WikiLeaks, look at what we did to the people at Guantanamo and elsewhere around the world. That is a government that acts without constraints. So the last point I want to make is the question about what can be done about this. And the reason why I like to end with that is because otherwise, what happens is if you gather together in an event like this and you spend an hour or an hour and a half talking about all these really systemic problems and these awful things that are going on, this kind of like gloominess sets in, you know, this sense of like, God, I just listened to this person for an hour talk about all these horrible things and I think I want to go lay in my room and close the windows or jump off a bridge or something. So I think it's important not to breed defeatism. And there's really no reason ever to have defeatism bred, because one of the lessons that we should learn from history, including very recent history, if you look, for example, at the Arab Spring, is that no matter how powerful certain institutions seem, or human structures, how formidable they seem, or invulnerable they seem, the lesson is always that any structure created by human beings can be modified or torn down by other human beings using the right methods. That is an indisputable truth. And, you know, I think the important thing to realize is that there's a certain way that the people who are benefiting from the system want you to react to the kinds of things that we're talking about tonight. There was this amazing article in December 2008, right before President Obama was inaugurated, which was really the first signal that he sent that despite all the promises he made during the campaign, he actually had no intention of authorizing or even allowing any investigations into the Bush-era crimes. And this New York Times article, I think unintentionally included this extremely important truth in the middle of this article. It said, the reason why presidents are so reluctant to allow investigations into the crimes of their predecessors is because they know that if they block those investigations, once they leave office, they too will have the same benefit. It's a class-based privilege. So it doesn't matter, Republican or Democrat, conservative or liberal, everybody in this class of political and economic elites has it within their interest to perpetuate this system of immunity, this two-tiered justice system. It protects themselves, and then law gets used as a mechanism of control for everybody else to entrench the status quo. And so the only way that we think about political change being permissible is by going to the ballot box and electing either the Republican choice or the Democratic choice. And what we're talking about tonight will never be changed by that process, because both of those parties have the same interest in preserving it. That isn't to say that there's no meaningful change that can happen by voting. That's something we all decide for ourselves. The point is that if any real meaningful change is to take place on this level, it has to take place not within the ballot box and within the process of voting for one of the two parties, but outside of it. Really movements by citizens to say that we're no longer willing to tolerate this radical unfairness. And you've seen the genesis of that movement in pretty substantial ways. If you look at the origins of the Tea Party movement, before it was co-opted by the Republican Party, it was very much a movement that was born in protest of the fact that the solution, the reaction to the financial crisis, was to reward the very oligarchs who caused it by bailing them out and making them richer at the expense of everybody else. And if you look at the roots of the Occupy movement, which I think is probably the most significant political development of the last decade, at least, you see that same template, the idea that we aren't simply protesting economic equality, the 1% versus the 99%, but that the 1% have really removed themselves from the constraints of law, that they are no longer bound by any of the same restrictions or constraints as the rest of us. And those movements, both of them, really began to put some fear, some much needed fear, in the heart of America's elite class. But it was really just the beginning. But I think that template is so important for seeing how that change can be done. When people who exercise power don't fear the consequences of abuse, they will continue to abuse it. It's only once they begin to fear the recriminations that only the rest of us can provide will they cease engaging in that behavior. And that, to me, is really the principle that animates how this change has to take place. So with that, I thank you very much for coming and for listening.
So questions for Greenwald?
What is the legal profession doing about this? I mean, we have prosecutors brandishing guns, saying how many people they've lost away. Nothing being done about prosecutorial misconduct. There are so many bar associations and law firms. What is happening about this? Why is nobody talking about that? What is the profession doing?
Yeah, I mean, very little, unfortunately. I mean, I think you see, there are certainly organizations that from the beginning of, say, September 11th have been very stalwart about opposing these kind of abuses. Of course, the ACLU, the Center for Constitutional Rights, and others have been pretty assertive from the start in a very principled way. And once it became safe, you then began to see law firms doing pro bono work on behalf of Guantanamo detainees to defend habeas corpus rights and the like. But I think the bigger problem is not so much the legal profession, although it is. It's really the federal judiciary. Because it's the federal judiciary that really is supposed to provide the refuge of last resort to people who are being persecuted by the political branches because they're unpopular and powerless. That's why they have life tenure, that's why they're immunized from elections. And what you see in the federal judiciary is really extraordinary. The most amazing fact to me is that it isn't just that, say, if you look at the war on terror abuses, the people responsible for those crimes haven't been prosecuted or held accountable. What's even more amazing is that the victims of those abuses, people who were tortured even though the government acknowledges they did nothing wrong, people who were rendered to Syria and tortured by mistaken identity, people who were in prison for years without charges and then exonerated, have tried to sue in American courts for some form of redress, and federal courts uniformly have slammed the courthouse doors shut in their face, not even allow them to have their cases heard, let alone seek justice, even when they were able to do so elsewhere. And you see this in the criminal context as well. Federal judges continuously siding with the government over criminal defendants. It's become an institutionally biased branch of the government that rather than checking the federal government has really become its prime enabler. And I think that's one of the most significant problems in all of these issues that we're discussing, is that the institutions designed to check these abuses have become complicit.
Go to the side.
It seems that any number of federal judges missed their day in class with regard to Article 6, Paragraph 2 of the U.S. Constitution. We just had a situation here fighting in Air Force days where 3 people tried to engage in civil resistance and deliver an indictment of the commander of the post for their own crimes. When they went to court, Attorney General Ramsey Clark came to Jeff City. He was not allowed to testify regarding Nuremberg, Geneva, etc. You see this in your tracks?
Well, I mean, a couple of things. I mean, one is the problem with federal judge, it's a complex problem. And you don't want to overgeneralize. There are a lot of very good federal judges who have actually stood up to the federal government. There was just a recent federal judge in New York who permanently enjoined the indefinite detention provisions of the NDAA, the law that was passed by Congress at the end of 2011, authorizing indefinite detention of American citizens. The problem is that federal judges are put through a very rigorous process in Congress and selected by the president, where they're basically people who are institutionally and culturally biased toward authorities. So the people who work in large law firms and defend corporations, or who come from prosecutors' offices, or who have otherwise demonstrated their fealty to the status quo. Very few of them make it through that process unless that happens. So you have large numbers of federal judges devoted to that as an ideology. And then on top of that, the idea that anything like treaties or any kind of foreign conventions has any impact whatsoever on American law, even though, as you say, the Constitution declares it to be the supreme law on par with statutes and everything else, is considered a far left-wing radical concept and will get you laughed out of court rather than any sort of remedy.
Here, we'll take this last question, then we'll go with the panel, and then there'll be time for questions after the panel as well. So.
Yeah, earlier you mentioned that you don't really foresee any solving our problems through continuation of red versus blue in the voting booth. Do you think that it'd be a worthwhile response to rejection of that system to hop on the train and support a third-party candidate such as Gary Johnson, who will be on the ballot in most, if not all states?
I mean, I think everyone has to make that decision for themselves, and part of it depends, I think, a lot on where you live and what the impact of doing that will be. I think it's a lot easier to do that if you're in a state where the outcome is guaranteed than if you're in one where it isn't. But I think ultimately the dynamic that always has to be weighed is every election gets decreed to be the most important ever, which is a way of ensuring that you never, ever consider any option other than voting for one of the two parties. It keeps you locked into that system, this mythology. And really what ultimately has to happen is, it is generally true that in every single election there are minimal differences between the two candidates. And these minimal differences, I don't mean to trivialize them, can have very important impact on the lives of lots of people, so they're not easily dismissed. So that short-term impact of your action has to be weighed against the need for midterm and longer-term reform, so that we don't constantly end up beholden to the same system. So if we keep continuously pledging fealty to it, it'll perpetuate itself forever. And how that gets weighed, the willingness to sacrifice some short-term harm for longer-term reform, depends on a whole bunch of different circumstances. I think everybody has to weigh those priorities for themselves.
Thank you.